Well, you've probably heard the term quiet quitting when employees stop going above and beyond and stick to the minimum requirements. But do you know about quiet firing? The term is gaining traction on social media, and here to explain what it is and what you need to watch out for is employment lawyer Alex Lucifero, partner at Samfiru Tumarkin LLP, who joins us now. Good morning, Alex.
Morning, Stefan.
I want to paint a hypothetical picture for you. Let me know if this sounds like being quietly fired. Let's say you're working retail at a retail center and your manager stops scheduling you for shifts. You're part-time, you're not guaranteed shifts, and slowly you kind of see that you're getting less and less on the schedule. Would that be an example of quiet firing?
It certainly is. I mean, it's a classic example. I think one would say quiet firing is effectively, a phrase that represents the disruption or the deterioration of the employment relationship from the employer's end. And that can happen certainly much more subtly than you just described, or it could happen very, very overtly. And so any significant changes to the terms of your employment, any significant reduction in your hours, or perhaps a temporary layoff, or a significant change to your job responsibilities can certainly be a quiet firing. It's what we call a constructive dismissal. Constructive dismissal is effectively a breach of contract, and that's what a situation such as that describes. More concerningly, however, it can be more subtle than that, Stefan. It could be your employer not assigning you new tasks, or not promoting you, or not being as communicative with you, kind of ostracizing you, for example, not inviting you to meetings. That is a much more subtle quiet firing and a much more difficult situation to handle for an employee.
So what do you do if you suspect that's happening to you? Because you could confront your employer and then they could say that's not actually the case, and that could damage the relationship further.
Yeah, certainly the more overt examples of quiet firing. So again, any major changes to your employment, you need to take action right away. You cannot accept those changes. You cannot even implicitly accept those changes by being quiet. You need to take action right away. You need to tell your employer you don't agree, for example, with this significant cut to your hours, or you don't agree with a significant change to your job responsibilities. You may also want to speak to an employment lawyer in a situation like that. Employees have rights. They would potentially have the right to severance in a constructive dismissal situation. The more subtle examples that we described, I think what you need to do is start taking notes of the situation, keeping track of the situation, and communicating your concerns to your employer, whether that's an HR department or your direct boss or the owner of the company. If you work with a small company, you need to start communicating your concerns and putting them on the record. So at the very least, if things get progressively worse, you have evidence. You have evidence of the concerns and the difficulties you faced already.
And when is it that you would use that evidence? So you're documenting, you're taking notes, you're tracking all of your employer's actions. When is it time for you to take action yourself?
Well, the legal rights that are triggered on the part of an employee is, again, when a significant changes occur. So again, those subtle minor changes of perhaps not being invited to a meeting or not communicating as much with your management team, the first few examples of that, again, you may not be able to do much about other than keep track of them. If that happens gradually over time, or if you become increasingly isolated in the workplace to the point that you can't do your job, that would then trigger, again, that point of constructive dismissal where you would effectively allow to say, I'm not accepting this situation anymore. I'm treating it as a breach of contract. And in a situation like that, then you can actually resign your employment as an employee and still obtain severance. That's what a constructive dismissal effectively is. Now, before employees go out there and resign their employment and claim constructive dismissal or claim quiet firing, again, you do want to speak with an employment lawyer in a situation like that. The analysis is always case by case and individual.
In a situation like that, does it take a long time to settle some of these terms, or take it to trial or what have you, and present the evidence and maybe get that severance that individual's owed?
Yeah, it is a misconception that a lot of these employment disputes are contentious and drawn out. The reality is most of them aren't. Most of them are quite easy to resolve. Employment laws are quite favorable to employees. They're actually quite straightforward as well. Employment law isn't a particularly complex area of law, and so a lot of these situations can be resolved quite easily. Of course, there's always the exception to the rule, and that's usually reserved for the most complex of cases, which we don't see terribly often.
Okay. Is it safe to assume that employers go this route because they want to avoid any lawsuits around wrongful dismissal. So it's more of a quiet firing so that this individual is so unhappy they leave on their own?
Yeah, I do think a lot of times it is a decision that's made for financial reasons. And so an employer would much rather an employee resign their employment. And if that means pushing them out, again, whether that's subtly or overtly, forcing them to resign effectively means not having to necessarily pay them severance. As opposed to simply terminating an employee, even if there are some concerns about conduct, even if there's some concerns about performance, if you let an employee go, you would still owe them severance, and your severance entitlements as an employee could be very, very significant. I mean, they could be as much as 24 months, 2 years of pay for longer service employees. And of course, if an employer can, at least most employers, they'll want to avoid that legal obligation.
All right, so important to know our rights. Alex, thank you so much for joining us.
My pleasure.
Enjoy the rest of your morning.